Hello there, folks. Jason Felsing, instructor here for the J. Harris Academy of Police Training. Here with another roll call training. We have a very interesting traffic stop DWI kind of mashup case here. It's the state of New Jersey versus Mellody. It was just handled or decided rather by the appellate division. It was published on July 5th, 2024. I teach Title 39 for J. Harris throughout the state, and I love DWIs. So this case is really something to kind of understand moving forward. So let's delve into it. All right, starting with our fact pattern. On November 1st, 2019, the defendant went to a tavern where she saw her neighbor. The defendant and her neighbor left the tavern separately around 10:30 p.m. Around 10:44 that night, police received a 911 call reporting an erratic driver, that's key, in the Crystal Springs development area. The caller reported that the driver was swerving and going over curbs and described the car as a black Jeep SUV and provided the license plate number. An officer was dispatched to the Jeep's registration address in an attempt to locate the erratic driver. Upon arrival, the officer observed a Jeep in the driveway matching the description from the 911 call. The brake lights were illuminated at that time. The officer activated his overhead lights to effectuate a traffic stop. The Jeep moved forward into the attached garage and stopped after the officer heard a loud bang. He surmised the Jeep struck a refrigerator located in the one-car garage, the beer fridge at the front of the garage, where he characterized that garage being tight. The officer entered the garage and saw the defendant sitting in the driver's seat. At the suppression hearing, the officer testified he asked the defendant what she was doing, why she didn't stop when he activated his lights. He also asked her something in relation to why she crashed into her fridge. He noticed the defendant's movements were fumbled and slow, and that her eyes were watery and bloodshot red. The officer smelled alcohol emanating from the vehicle. All key signs that we know are just dead ringers for DWI impairment. The officer instructed the defendant to turn off her engine and exit the vehicle so he could administer the field sobriety tests. While performing the walk and turn test, the defendant lost her balance and took an incorrect number of steps. She was also unable to perform the one-leg stand test. She was subsequently arrested and transported to the police station. She was then charged with DWI, which is 39-450, careless driving, 39-497, and failure to comply with the direction of a police officer, 39-457. A really good statute there. For the initial trial, the officer who initiated that stop and made the arrest was the only witness. The state also introduced portions of the 911 call and the dash cam recordings. The judge noted that the dash cam video speaks volumes and shows somebody who's clearly intoxicated, so even somebody that's not dealing with drunk people on the street acknowledged that. The judge described the defendant as wobbling, zigzagging, crying, upset, and emotional with slurred speech. At trial, the parties agreed they would use the officer's testimony from the suppression hearing. The defendant testified on her own behalf in this case. She claimed she was in the process of parking her car and that the refrigerator is located directly in front of it. She maintained that she did not hit the refrigerator or hear a crash sound. She did not see any damage on the refrigerator after she looked at it at that point either. She also stated the reason why she didn't stop when she had the lights illuminated behind her was that she believed that the officer was pulling over a neighbor or he was a house over or something like that. On November 18th of 2022, the Law Division judge issued a written opinion upholding the convictions and sentence. The Law Division judge found the officer had reasonable and articulable suspicion, the RAS, to stop the defendant's vehicle, citing State v. Galata, which is a Supreme Court case from 2003. The judge determined that the 911 caller should not be treated as an anonymous tip based on the quality of information that they provided to the operator. The information provided here, they obviously gave the clear description of the black Jeep. They gave the registration number, so that officer was able to go to that registered owner's address. And also all the different things that driver was doing, driving over curbs, swerving, leaving a tavern. So it was a really quality 911 call. The judge also concluded that the officer lawfully entered the garage, reasoning that the combination of the erratic driving report coupled with the defendant's driving her car after the patrolman engaged his lights and siren, and then running into a refrigerator all raised serious concerns for the health, safety, and welfare of the driver that necessitated follow-up action from that officer. The patrolman testified that he observed a crash and that he was not sure if the defendant was okay or not, which is why he entered the garage. These facts provided the patrolman with an objectively reasonable basis to believe that the driver may be impaired or suffering a medical emergency. That's taken from State v. Scriven, which is a Supreme Court case from 2006. The defendant, of course, appeals, and that's why we're here. If we reference State v. Evers from 2003, the Supreme Court there stressed, the privacy interests of the home are entitled to the highest degree of respect and protection in the framework of our constitutional system. The special protections afforded for the home apply to the defendant's garage. The attached garage is part of her home, or at the very least, part of the home's protected curtilage. For constitutional privacy analysis purposes, a garage is not just a place to shelter vehicles from the elements. Personal effects, protected under the Fourth Amendment and the New Jersey Constitution, might as easily be stored in a garage as in a basement, an attic, or a bedroom closet. Indeed, in this case, the defendant kept a refrigerator in her garage. Continuing on, it makes no difference that the garage door was open when the officer crossed the threshold. A large open door does not invite police to enter a garage without a warrant or recognize exception to that warrant requirement, any more than an open sliding glass patio door invites police to enter a family room. While an open door may expose to plain view certain contents of a garage, even then, police may not enter the garage based solely on the plain view observation of contraband inside. That's State v. Johnson, an appellate division case from 2023. The plain view exception does not authorize police to cross the threshold of a constitutionally protected place, nor does it apply when the officer has no right to enter a private residence. The garage is part of the private residence here. It also does not matter that the officer acted in perceived good faith and may not have appreciated that entering the open garage was an act of constitutional significance, qualitatively different from walking up to a vehicle stopped on the highway of a regular traffic stop. The court focuses solely on the officer's conduct, not his or her subjective thoughts. Because the test is an objective one, not subjective, there's no good faith exception to this exclusionary rule. The court further found that this was not a fleeting or de minimis entry into the defendant's home. We can't just throw this off like a small banana theft with one of the famous de minimis cases. Here the officer entered the garage to execute an investigative detention, that is, to seize the defendant. He was looking to make an arrest for DWI. Police cannot conduct a warrantless entry into a home to detain a resident without consent or a recognized exception to the warrant requirement, such as exigent circumstances. And this is where we get to the real meat and potatoes of the decision of the court here. Here, the officer's testimony does not suggest he acted with any special urgency consistent with rendering emergency aid. To the contrary, his testimony suggests he approached the defendant's stationary but running vehicle in much the same way an officer would approach any vehicle stopped on any roadway on suspicion of drunk driving. The officer did not begin the encounter by asking the defendant if she needed any medical assistance, either because of a medical condition explaining her erratic driving, or because of injury resulting from the crash. As far as the record shows, at no time during the encounter was the defendant asked if she was injured or ill. Instead, testimony shows he entered the garage to conduct a DWI and careless driving investigation only. Finally, the court looked at community caretaking and exigent circumstances exceptions. Performing a community caretaking function does not constitute a standalone exception to the warrant requirement for purposes of authorizing police to enter a private residence. Rather, any such warrantless, non-consensual entry is justified only under the exigent circumstances exception. So, of course, by applying an objective test, the state failed to prove by a preponderance of the evidence that the officer lawfully entered the garage to render emergency aid. Because the warrantless, non-consensual entry into the garage portion of the private residence does not satisfy the exigent circumstances exception, the entry was unlawful. The field sobriety tests, and the officer's electronically recorded observation of the defendant's physical appearance and demeanor occurred after the unlawful entry into the garage. Thus, they are fruits of that constitutional violation and must be suppressed. The defendant's DWI conviction is reversed and vacated. The big issue that I have here, especially being a proactive officer, supervisor, having officers trying to, make sure that DWIs aren't happening and filing them to their fullest extent, it's going to be hard for officers to believe that they've watched a vehicle drive into a garage after they were seemingly lawfully stopped with their lights on and their siren on, and then they thought that there was an accident. I think the issue here could have been report writing. Again, I'd like to get my hands on that report. But the big issue really was you can no longer continue on, right? You can't continue that traffic stop into somebody's residence. Curtilage has become far more protected in recent cases. And now certainly a garage, they mentioned it being like curtilage, but garage is part of your residence. I have an attached garage in my home. I wouldn't expect anybody to be able to just walk into my garage without some sort of exigent circumstance. So it's a tricky case. I'm not going to say it's necessarily a bad case. I think it's an eye-opening case. I think that officers, either yourself or if you're a supervisor, you're on some sort of traffic unit, this is a great roll call training to listen to, just to kind of reaffirm the fact that even though you initiate a traffic stop, We certainly didn't get some sort of eluding here, so that's going to be a whole different circumstance. Hopefully report writing could fix a little bit, maybe if there was a crash, and if they went that other way, talking about medical aid. But again, the testimony never said that he asked that defendant anything about her medical status, if she was ill, injured, or anything like that. So community caretaking is simply off the table. That sums up the Mellody case here. Again, I want to thank you for listening to this extended roll call training. I am Jason Felsing, an instructor for the J. Harris Academy of Police Training. I look forward to bringing you more roll calls as they roll out pertaining to DWI or Title 39. Other instructors may bring other type of case law issues, and we do really value putting these out as often as we can. So please stand by for further training. And as always, please be safe out there.